Welcome everyone, and thank you for joining us today. My name is Melanie Chasteen, and I'm the Director of Community Engagement for the Texas Campaign to Prevent Teen Pregnancy. We are so excited to be hosting this session today, which will explore the integration of medical legal partnerships in healthcare settings and how these partnerships can improve health outcomes for at-risk youth. Today's presenters are joining us from the Texas Legal Services Center and the Kind Medical Legal Partnership. Next slide. I'd like to give a huge shout out to our webinar series sponsors. We are so thankful for their ongoing support and feel really fortunate to know that they are in our corner working toward improved adolescent health outcomes. Now, before we dive into today's session, I want to share a few tips for using the webinar platform, even though I feel like everybody is probably an expert by now. Also talk to you a bit about our new continuing education process and give you a bit of background about the Texas campaign. Next slide. First, as you all probably know, platforms such as Zoom have been experiencing technical difficulties due to the amount of usage since the COVID-19 outbreak. Should there be a problem during this webinar, we will do our best to solve it. If we are not able to solve it, we will make the slide deck available and if necessary, work with the presenters to reschedule. We have muted all participants to help reduce background noise, but we welcome your questions using the Q&A function you see at the bottom of your screen. We will leave time at the end of the webinar to answer the questions, but you can submit your questions at any time during the presentation. When the webinar is complete, an evaluation will pop up. You will receive the same evaluation via email. Please take a moment to share your feedback so that we can continue to improve. For those seeking continuing education units, this evaluation is required. Next slide. Most of our CEs are now provided through the Texas Department of State Health Services Continuing Education Service. Only participants who listen to the complete webinar live are eligible. Certificates will be emailed out within 30 days of the webinar. Next slide. And just a reminder that the evaluation must be completed within 2 weeks of the live webinar. Next slide. Along with the list of CEs you see here, the Texas campaign also provides continuing professional education units through the Texas Education Agency and community health worker units through the Texas DSHS Community Health Worker Training and Certification Program. There is a place in the evaluation to note which CEs you are seeking. Next slide. I want to extend a warm welcome once again to everyone joining us today. For those who may be engaging with us for the first time, the Texas Campaign to Prevent Teen Pregnancy is a statewide, nonpartisan, nonprofit organization dedicated to reducing teen pregnancy through research and data dissemination, advocacy for effective public policies, strategic collaborations, as well as training and events. We have the privilege of working with a diverse group of stakeholders from across the state to achieve this mission. Last year, we began leveraging the power of webinar technology to increase our engagement efforts. Little did we know that in 2020, we would take all of our programming online, which brings me to one final note. Next slide, please. Today's webinar was part of our symposium programming and is the second in our series focused on working with special populations. We will be presenting a different theme each month through December. You can see the remaining webinars for May up on your screen, and all details can be found at txsymposium.org. And now, without further ado, I'll pass this along to Cassandra and Wesley.
Good morning. My name is Cassie Gonzalez, and I'm an attorney with the Medical Legal Partnership at People's Community Clinic.
Hi, I'm Wesley Hartman. I'm an attorney with the Medical Legal Partnership at Kind Clinic. Yep, so we are staff attorneys employed by Texas Legal Services Center, which is a nonprofit law firm that operates statewide. We are 2 of the 4 attorneys in our medical legal partnerships department, which is designed to integrate us into the clinical setting so that we can work alongside the care team to help detect, prevent, and address health-harming legal needs.
So People's Community Clinic is our oldest clinic partner. That medical legal partnership was established in 2012 with an Equal Justice Works Fellowship. I also received that same fellowship to expand the current medical legal partnership to specifically focus on working with pediatric and adolescent patients. I particularly work with the population at People's Manor Mustang Health Center, which is a school-linked health center about maybe 20 minutes just directly east of the People's main clinic. But I do still serve the clinic as a whole.
Yes, and I joined in 2018, also started off as a fellow to expand our medical legal partnerships department to add Kind Clinic as a partner. And so I focus on working with the LGBT community, people living with HIV, and anyone seeking sexual health services, and have a particular specialization with transgender and non-binary patients. So we just wanted to outline some of the basics of our program, and we'll talk a little more in depth now about medical legal partnerships and what is a health harming legal need.
I'm going to start with, just like Wesley said, an introduction as to what a medical legal partnership is and how it works. It is a national model that deliberately incorporates attorneys into the delivery of healthcare. So at its simplest, MLP means that in the same way, someone with a heart problem is referred to a cardiologist, or someone with a foot problem is referred to a podiatrist, well, someone with a legal problem can be referred to an attorney. At its best, MLP is so much more than just doctors or providers sending referrals. It's really the ability to transform lives through concrete interventions and to take actions that can improve the well-being of entire populations. And specifically for my work, I focus on improving overall health outcomes for at-risk youth. And this is an integrated approach that allows the healthcare team that I am on to take a holistic approach to the patients that we serve, because medicine alone or diagnosing a problem like asthma, can't solve the problems caused by hunger or poverty. And you can also see in my note that in rural areas, MLP lawyers often work remotely. We are fortunate to be on site with the clinic, not right now because of COVID, but before this all happened, we do serve our clinical partners on site. And notably, the American Medical Association, the American Academy of Pediatrics, and the American Bar Association have passed resolutions praising MLP. I'm going to talk a little bit about what health harming legal needs are and how we assess them to try and improve the health outcomes of the patients we work with. So social determinants and social needs impact health. We know that where people work, live, and play determine how healthy they can be. And many of these are legal needs where the provision of legal care can improve the health outcomes. We have a mnemonic in the medical legal partnership field to remember the main issues we try and look for as we are working with patients. It is known as I help. So you can see the first section would be income, and I do quite a few of these cases, especially for children and youth that may have disability benefits denied, and having SSI benefits can attach to a person also having Medicaid. So if they don't have health insurance, it's a really, really big win and big help for the family to not only have that financial support, but also that health insurance. We also have housing and utilities work, which we've seen a lot during this COVID crisis. These cases will be referred to me from a provider, and usually, if it's the adolescent or youth that's experiencing the hardship, but I get to work with the family as a whole. Education and employment, also another area. We I was doing a lot of counseling on ARD meetings and parents being prepared to go before the school and ask them if they need more accommodations for the youth or the kid. We also have legal status and personal stability and relationships, which can involve family law as well as simple estate planning. So I want to talk a little bit about the interdisciplinary approach we're able to take in a medical legal partnership. You will see on the right side of my screen a tweet actually from one of the doctors at People's Community Clinic. This was tweeted after a case staffing session we had, where we actually got to sit down and discuss two patients in their teenage years with really complex legal needs, social needs, medical needs. And I was able to be there with a social worker and a doctor, and together we could come up with a case plan that really provided wraparound services. And you can see here that the doctor I worked with, Dr. Neville, we were also piecing their stories together. So social work might have had a piece that I didn't have, and the doctor had a piece that none of us had, and through that we were able to get a whole picture of what the family was going through. We also do consultations, and this usually involves, we field and answer questions from providers. One issue that has been recurrent and popular involves minor consent and privacy issues. So we are going to talk a little bit more about this area. And then the referrals process, in case it wasn't clear, we receive referrals from healthcare providers. This can be from a social worker, a community health worker, a financial counselor, a physician, and we do have access to the electronic health record. So referrals are sent that way, and then we can put them within our legal system and follow up accordingly.
Yeah, so we just ask you to keep these two case studies in mind as we proceed with the rest of our presentation. We will come back and discuss these more in detail and hopefully answer most of them before that. But yes, one of our first recent examples is that a minor is requesting pregnancy testing but doesn't want mom to know, but mom's invested in care and has been working with the clinic on other medical issues for the minor. And so the provider first reaches out to us to ask, what can we do in this situation about the minor not wanting her mom to know about the pregnancy test?
Yeah, and you can see in the second example, this happened recently as well. An aunt arrived at the clinic with a minor patient also in her teenage years, and the aunt wanted to consent to her treatment, but the clinic staff, wasn't sure if she was authorized as a consenter. There was no written statement from the minor's mom, and the patient and her aunt were referred to me to determine if they needed legal documentation for the aunt to be her legal consenter.
Yeah, so with that, we will dive into the substance of our presentation. As Cassie mentioned, we feel like one of our biggest impacts in this interdisciplinary area is that we as attorneys can weigh in on consent and confidentiality when it comes to minors accessing care. It's a really, really challenging area because it requires medical providers to analyze and understand really complex legal rules. And so we recognized, lots of providers, especially, if you're a nonprofit or in private practice, you're having to rely on sort of a non-attorney attempt at interpreting the law. Or if you do work at an organization that may have general counsel, you probably have to defer to that general counsel's position on these legal issues. But general counsel's primary concern is with the entity's own liability. They will tend to be more conservative in their approach. And so I hope this will be a different perspective to hear from attorneys who advocate on behalf of patients to help them access care to the maximum extent possible and as confidentially as possible. You'll do next slide. Yeah, so starting with our basic premise, legal capacity, the ability to make your own decisions, sign your own legally binding documents, begins at age 18. So by default, anyone younger than age 18, their parent, guardian, or conservator has to make decisions or consent to medical treatment for them. So what we'll be looking at are the exceptions to that general rule. Right? There are certain classes of minors and certain services for which minors can consent without otherwise having a legal guardian's consent. And this is true of lots of general case law, right? When it comes to contracts or other privacy law, consent is a broad topic that applies across multiple areas. We're just focusing in on this medical consent piece. Next slide. We will start with different classes of minors that are allowed to consent to their own medical treatment. So the first and simplest example is minors that are emancipated. If you've been emancipated, you are sort of legally declared an adult before age 18, and so you have all of the decision-making rights of an adult to handle your own medical care. The unfortunate piece is that emancipation almost never happens. It requires the minor to be self-sufficient. I think it's very rare to find a 16 or 17-year-old who's able to support themselves and can demonstrate they will live totally independent of anyone else. And it's also a time-limited issue, right? It may take months to resolve a legal case, and if the patient is already 17 and will be turning 18, that issue will resolve itself before they need to worry about taking any legal action like emancipation. Married minors are also allowed to consent to their own medical treatment. This is a kind of a trick category because in 2017, the Texas legislature prohibited minor marriages. So now all people have to be 18 to get married. So this is still in the statute. If you look at the Texas Family Code regarding consent, it's Family Code 32. And I think demonstrates one of the difficulties in trying to interpret law, where if you read the statute, it looks like, oh, there's maybe some class of married minors that can consent to treatment. But actually, minors can't get married anymore. That's been swallowed up by the emancipation exception. Foster youth is one we really commonly see. So if they are 16 or older, they can seek consent from the judge who is overseeing their foster care case to be able to make their own medical decisions. Active duty service is not one we commonly see, but any minor on active duty is able to consent. Although keeping in mind they may have had, if they're a minor, they may have had to have parental consent in order to enlist in the first place. Living apart from parents is probably one of the more common ones that we see. Any youth who is 16 or older living separately from their legal guardian with or without permission and managing their own financial affairs, regardless of the source of that income, right? So the parent might still be totally financially supporting them, but as long as they're not physically living with the parent, they are allowed to consent to essentially all care: medical, dental, psychological, surgical care. And then we have a couple of related exceptions for pregnancy and parenting. A pregnant minor is allowed to consent to treatment related to the pregnancy, although of course there are special rules around abortion. And any minor that is parenting can consent to the medical treatment of their own child, right? Which is a bit of a paradox that you could, consent on behalf of your own child to treatments that you couldn't actually consent for yourself. And then the last class is incarcerated minors who are allowed to consent to their own treatment while incarcerated. And I think the important piece to take away from these is that the medical provider can rely on the written statement of the minor regarding the grounds on which they have the capacity to consent. So, you don't have to do any, special investigation. If the minor is coming in telling you, I'm 16, I'm managing my money, I'm living apart from my parent, I can consent to my care, that is acceptable for consent purposes. Next slide. So those are our classes of minors that can consent, and we'll look now at specific types of care that minors can consent to. Starting with non-reproductive and sexual care, minors can consent to emergency care, right, based on the idea that it's really life-saving. You can't wait around for consent if you need to treat the child immediately. And similarly, youth can consent to emergency shelter and care at age 16 and up. And then we have a couple of related exceptions for mental health services. So minors 16 and up can request either inpatient or outpatient mental health services and can consent to just general counseling for some specific reasons, for suicide prevention, chemical addiction or dependency, physical, sexual, or emotional abuse. And that can be provided by a variety of different providers, a physician, psychologist, social worker, or other licensed counselor. Similarly, minors are generally allowed to consent to treatment for drug or chemical addiction or dependency and any condition directly related to drug or chemical use. And our last exception actually relates to pregnancy and parenting again. If a minor is pregnant or is a parent of their own child, then they can consent to their own immunizations so long as the CDC recommends the first dose of that immunization before age 7. Next slide. So this will be our last set of exceptions, which is for reproductive and sexual care. So minors are sometimes allowed to consent to family planning and contraception. There is no general state law that gives them that right, but under Title X and with Medicaid funding, a minor can consent to their own family planning. Minors can also consent to diagnosis and treatment for any reportable infectious disease, including HIV and AIDS. Yeah, and if you'll go to the next slide, we'll talk a little more in depth about the family planning piece, especially since there have been so many recent changes. Again, there are special rules regarding abortion. That's a little bit outside of our practice area, but I just want to acknowledge, right, we had a recent controversy surrounding the ability to get abortions during COVID-19. The governor attempted to add some new restrictions around abortion as an elective service. Those obviously challenged, but the restriction on elective procedures was lifted before any of those cases were resolved anyway. But it definitely affected access to care. Many legal service providers, If, When, How, and Jane's Due Process reported right? They had a really high call volume and a lot of requests for legal services during that controversy. And Title X obviously had some rule changes over the past year, primarily the gag rule and the requirements for physical separation. Multiple lawsuits were brought over the gag rule in particular, but while the district courts initially, prohibited the rule from being enforced, appellate courts overturned those injunctions and allowed the rule to be enforced while the litigation is still proceeding. So the gag rule went into effect last fall. Physical separation requirements went into effect in March 2020. Right, so physical separation requirements means any provider offering abortion services has to entirely separate those services from anything else that's supported with Title X funding. So that means separate financial accounting, separate medical records, separate physical space with different entrance and exit, which is just a huge cost to entirely renovate your practice. It's a major reason why Planned Parenthood gave up Title X funding. Many other clinics elected to give up funding because of the gag rule, which we originally was supposed to be a full gag rule that clinics could not counsel on abortion at all. That is not the final rule as it is now in effect. So Title X clinics are still permitted to provide non-directive abortion counseling, but they are prohibited from making a referral. So for referral purposes, providers can only give pregnant patients a list of local providers, but neither the list nor any of the program staff can indicate which of those providers offer abortion-related services, and providers offering abortion services cannot make up a majority of the list. So if you've got 2 abortion providers on your list, you have to put 3 providers who do not offer abortion-related services. Right, so it's had a massive impact. As many as 1,000 or 1 in 4 clinics that receive Title X funding have decided to give it up, and potentially many more have given up funding since the physical separation requirements went into effect in March. And almost no new providers are opting into these funds, which leaves a huge gap in care, right? Especially in Texas, where there's no ability for minors to consent to their own family planning confidentially. We relied on Title X and Medicaid, and now Medicaid is really the primary exception we have to rely on. So no new providers are opting in to cover the gap, with one notable exception I'd like to point out, which is the Obria group in California. And they do not practice evidence-based medicine. They offer abortion pill reversal services, and they're reported to endorse abstinence-only sex education. So I think, not only are patients potentially losing access to care, but they're being railroaded now into harmful care if groups like Obria pick up funding. As you can see, this is an estimated impact on 1.6 million patients nationwide, and primarily lower income, uninsured people of color who rely on Title X clinics for their services. And next slide.
So I'm going to talk a little bit about other consenters. What happens if a minor needs one of the services we talked about, but the parent, conservator, or guardian is unable to consent? I've seen this a lot, especially with a couple of my youth teenage patients that have maybe come and are seeking asylum. There were quite a few of those recently, and their parents stayed in Mexico or wherever they were, and so now they're with a family member, and there becomes that issue of, well, parents not around to consent, so what do we do? So under the Texas Family Code, if there is no actual notice to the contrary by the person having the right to consent, so if mom hasn't written, you can't consent to medical treatment to aunt or something of that sort, then surgical treatment, dental, psychological, medical, all of these treatments can be consented for by grandparents, adult siblings, adult aunts and uncles, and step-parents can only consent to immunization. But the one that I've frequently seen, in fact, I think I've seen all of them except step-parents, the adult aunt, the adult sibling, and the grandparents. And most of the time I'd say it's happening in mixed status families, at least from my recent referrals. And then for court-involved minors, consent can be obtained from the court with jurisdiction over a custody dispute. There are exceptions that allow law enforcement, CPS, or foster parents to consent. So now I'm going to talk a little bit about privacy and confidentiality. So as you all know, there are limits on confidentiality. And if someone is being treated by social work, you know, I've received this question of when a high schooler is talking about being sexually active with someone that's older than them, when do they report it as abuse? And a lot of times the age differences will come into play. And the stereotypical answer from us is, it depends. But regardless, there are limits to confidentiality, and that includes abuse, suicide, homicide, ideation and thoughts, and reportable diseases. And while, you know, we do have HIPAA as protection and the Texas Medical Privacy Act, Medical Records Privacy Act, that means that generally parents and caregivers, grandparents, they can get access to a minor's medical record. But what happens if that minor doesn't want them to access it? Providers may be able to refuse when the minor consents or someone else consents for them, and they can also deny it if they think that the minor is being subjected to violence, abuse, and neglect, and releasing it would cause harm. Nonetheless, Texas law authorizes providers to still advise the parent, caregiver, or grandparent of the treatment that a minor may be receiving, regardless of whether the minor consented. So I recently had a case where a patient was 17 years old and 9 months, 17 years and 9 months old. She had already moved out of her mom's house, was trying to establish herself financially, was not dependent on her mom, and didn't want her mom to have any access to her health information. People's Community Clinic actually put an alert in her chart. So when I went to review medical records, you know, I saw the alert that specifically said no PHI sharing with mom. And, you know, the clinic respected her wishes. And this is actually one of the categories that Wesley mentioned earlier, you know, where if you're over 16 and you're financially independent, my client fit into that. So while the clinic, you know, could have chosen to still advise mom in this circumstance, there was an alert on her chart and it was made very clear that there wasn't going to be information sharing. There are some practical considerations to think about. Healthcare professionals don't need to investigate the grounds for ability to consent. Wesley mentioned this earlier. They can rely on the written statement of the minor. There's no liability to parents if they accept that minor's consent. You can see on the right side of my screen, this is actually from Planned Parenthood, and an example of the form that they're giving for the minors to be able to consent to their own treatment. You can see it at the bottom, consent by minor client. One of the options is emancipated minor, which Wesley talked about, and the other is the category where they're 16 or older, living apart and managing their own financial affairs. More practical considerations. So as far as privacy goes, I went over the medical records and information piece. There is mandatory reporting of diseases, and sometimes providers are going to disclose that health information. Payment and billing, I've gotten this question before. What happens if a teenager is trying to get birth control and they are 16 and a half or like 17 and a half, and the provider wants to keep that confidential for them. But the insurance claim, insurance is still going to be billed for it. And whether it's paperless or this mailed form they usually send, that can end up going to the parent's address or the parent's email. Bank accounts are also monitored by parents. So if a teen is trying to pay for certain things and parents are checking accounts, they might be able to find something out. We sometimes advise that patients can call insurance companies if they want help and maybe ask if the insurance company can limit information sharing in a certain way. Maybe EOBs can be emailed to a certain address, some way in which they might be able to feel more comfortable or more like their information is protected. But those remain just some things to think about practically.
Yeah, so with that, we will come back to our case studies. This has been a lot of information, so just give you all a chance to breathe. And I'd like you to think through now, think back on the presentation, see if you feel like you have a better understanding of the potential answer in both of these case studies. We'll give you like 30 seconds or a minute, and then come back and give you all our analysis of each situation.
And if you all have thoughts or specific questions, there's the Q&A chat box. There's a Q&A as well as the chat box.
All right, so jumping back in with our first case study, right, recalling we have a minor patient who needs a pregnancy test, does not want mom to know about the pregnancy test, but mom's been really invested in care and has asked a nurse to explain what's going on. So at this, we would likely need a little more detail from the clinic. But it sounds like if mom is really invested in care, then mom might actually be the one providing consent for care. And if that is the case, if mom is the medical consenter, then she should be treated as daughter's personal representative under HIPAA and is entitled to access her personal health information. Unless it fits under that narrow exception, if the provider feels like disclosing that information would put the minor at risk of abuse, neglect, or harm. That may not be the case, right? We may have a different argument if the minor was consenting to their own treatment, either right for family planning under Title X or Medicaid, or if they were consenting on their own some other grounds like living 16 and up, and separate from the mom, right, then we may have other reasons that the medical provider could refuse to release that information to mom. Yeah, and we're primarily focusing on this consent and confidentiality piece, and I think it's worth mentioning too, right, that if the minor is disclosing sexual activity that is necessitating a pregnancy test, right, that might trigger some mandatory reporting, and could also breach confidentiality if then CPS ends up contacting mom to investigate. So from a trauma-informed perspective, it may be a good idea to sit down and have that conversation with the minor, make them aware of what information you might have to share and in what way. And then I'd finally like to point out all of the other caveats about potential privacy breaches still apply, right? In terms of paying for the appointment if mom is monitoring bank accounts or controlling finances, or if it's billed to insurance and insurance may then disclose information to mom.
And for case 2, I mentioned this earlier, but under the Texas Family Code, the aunt is authorized as a class of adults that can authorize consent to care, so long as the parent hasn't told the clinic otherwise. So in this case, patient's mom, hadn't said anything to the clinic. Aunt could come in and consent for her care without a written authorization. However, the parent does have the option to sign an authorization that allows the aunt to consent to care, but it isn't necessary. Before I move on to the next slide, I did want to bring these case examples back to the idea that we are integrated into the healthcare team. This is a part of the work we do, and this still helps improve health outcomes, even if we're talking about things in privacy and confidentiality sense. I know a lot of the cases that I've talked about, these families and youth are stressed and dealing with so many other health issues, whether it's worried about pregnancy or access to birth control or housing instability. Like, all of these issues are layered into one case that we may be looking at. And I think it's particularly important to recognize during this time, as we're dealing with COVID-19 and what we're seeing in our program for adolescent and pediatric patients is shifting. We're thinking about things like privacy now, and Zoom bombing, and when people can get into a meeting, telehealth, what is really private, who has authorization, whether it's auto, doxy, or Zoom, and who's HIPAA compliant, things that I feel like we weren't thinking on as big of a scale as we're forced to do now. And we've seen huge impacts on social determinants of health for families and youth. For a lot of the patients I work with, they are of lower socioeconomic class, and employment and unemployment benefits is a huge one. I get the benefits, I get the referrals from the provider for a pediatric and adolescent patient, but it's still noted as, mom lost her job and is now really stressed about providing for the kids. And I'm providing advice and counsel on how to apply for unemployment benefits, what that may look like, checking to make sure if they apply, they receive the right amount. And employment goes hand in hand with food security and unstable housing. If I had a client on the phone a couple weeks ago that was struggling to pay rent, so I was able to counsel on protections around eviction at this time, but she did ask me, well, if I have to choose between paying rent and paying food for my kids, I'm going to pick food and just not pay rent. And unfortunately, those are some choices that people are having to make at this time. I've also seen a shift with a lot of the education work I've been doing with kids. Now, potentially we're going to remote disciplinary proceedings or special education proceedings. Cyberbullying was already a thing, but now with virtual schools and virtual classrooms, I think there's even more of an opportunity for that, and a lack of supports and services, because the schools, and I think the Texas Education Agency as well, nobody really knows what it's supposed to look like virtually because it's never been done before. So I'm also trying to figure out ways to still implement legal interventions to keep the patients that I work with healthy.
Yeah, and then finally, we'd like to point out, minors should feel empowered to seek legal services, and making sure they understand their own ability to consent to medical treatment, or if they need advocacy to convince a provider to accept that consent. Those are all absolutely appropriate for legal services. and may be able to get confidential legal services for many of these other social related issues around employment, housing, or education. So we had a brief list of most of the free service providers. They're obviously our medical legal partnerships, although our services for patients are sort of limited to our own partner clinics. There's also legal aid, 3 different legal aid organizations statewide that cover different areas. Texas Rio Grande Legal Aid covers Austin, and also has some specific foster youth justice project, which may be other ways for youth to access care. And then, of course, Jane's Due Process. I'd also like to mention, and I think this is an underutilized legal service, but legal aid has some limited ability to provide legal services for organizations. And that usually requires that your organization serves a population that would qualify for legal aid. So that's generally below 125% of the federal poverty line for a household. But that may be another way to get an attorney involved that might be more willing to take the patient's perspective into account and to help align your own practice with allowing minors to consent and receive confidential treatment to the fullest extent possible. Yeah, next slide. So we've got our contact information and social media for our programs. Feel free to follow us. If you have questions later, you're obviously welcome to contact the both of us, but we will break now to answer any questions you have during the presentation.
Hey, Cassandra and Wesley, a question came in via the chat box. Do you guys see it from
Yes, yeah, we have the question, do minors have to prove that they live separate from their parents? Is living with a friend considered living and managing financial status on their own? Yeah, so I'd say minors don't have to prove that they live separate from their parents because the provider can rely on the minor's written statement and doesn't have to do any other investigation. So if the minor is coming in, signing the confidentiality or the consent form saying, I live separate from my parents, you can just accept that. And yes, even if you're just living with a friend, as long as you're actually living at that place apart from your parent, I would generally consider that, living apart, manage your own financial affairs, and that minors should have the ability to consent to their own confidential treatment.
Another question came in via the Q&A. For written consent, does a written note need to be notarized to be sufficient? Cassandra, Wesley, can you guys hear me?
Yes.
Okay. Another question came in via the Q&A.
Right. Does written need to be notarized for consent? No, generally just any signature is fine.
Give a little more time for people to ask questions. I actually have a question and just wondering, has it ever come back to a medical provider who has just, taken the word of the young person who has signed this consent form that they're living on their own or they're separate from their parents or whatever the case may be, where that wasn't the case and then a provider, I don't know, got in trouble, for lack of a better phrase?
No, as far as I know, that has never happened. And because the statute is so clearly written about the provider being able to rely on the minor's written statement, that's really good insulation from liability. This didn't happen in Texas. I think it happened in Montana, but there was a recent case where a mom tried to sue a clinic because her child went in and obtained hormone replacement therapy under one of that state's like other consent laws that allow minors to consent for themselves. And that case was completely dismissed. I mean, that mother has no standing to sort of challenge the clinic directly in that way. If she wanted to, sue the state about their minor consent laws, that might be one thing. I think she'd still lose. But again, there's no direct liability for the provider in that situation.
Okay.
I'd also add that we work so closely with providers that I think if they were hesitant about accepting a consent like that or anything, they might reach out to us to talk with the minor first or assess the situation. But like Wesley said, it's never happened.
Okay.
Yeah, we see some similar disputes sometimes when there are divorced parents sort of vying for who can consent for care and who's receiving medical information. And as a general rule, most divorce orders give both parents equal right to medical care. So you just follow which parent says. If the parents are giving you conflicting information, right, that's something for them to resolve on their own through family law and the court system. That's not a dispute that the clinic should have to deal with.
Yeah. I feel like I've seen some of those higher profile cases on the media. They usually involve divorced or separated parents. So we'll wait just a teensy bit more for some more questions. We really appreciate Cassandra and Wesley, you guys joining us and sharing. We will be sending out an email with this video and slide deck to all the people on the call. I know I got some questions about that because it's a lot of information. All right, well, it doesn't look like there's any more questions, but if anybody thinks of questions after the fact, Cassandra and Wesley's contact information will be a part of the slide deck. And if, Cassandra, will you go to the next slide and we'll wrap up?
Yes.
So thank you everyone again who joined us. Again, lots of information to take in, and a quick reminder for those needing continuing education to please submit the evaluation. It's required to get your certificate. And one final plug for our symposium series. Complete details are at txsymposium.org, and we hope that you all have a great rest of your week.
Thank you for having us.
Yeah, thank you, everyone.